fellow, a legal fellow at the Northwest Immigrant Rights Project. And we're going to be focusing on trauma-informed representation in remote hearings, but I just wanted to acknowledge that trauma-informed advocacy is very near and dear to my heart, especially in the legal field. I think we're only just now starting to really explore this. When I was at NERP, when I was at the Public Defender's Office, trauma was something that was discussed as a part of the case, but it wasn't necessarily a part of how we were trained to be trained to advocate for survivors. So I'm really glad to be able to have this conversation with all of you this morning. We also want to know who else is here. Thank you for introducing yourselves in the chat. But we also, just to kind of get a sense of the full audience, we have a little poll. Amy, if you can launch the poll so we can see who else is joining us. And if you want to take about a minute to fill this out.
I just realized that when I was entering the poll this morning, I forgot to put advocate on there, and it was actually one of the first ones that Riddhi had sent to me. So my apologies for that. I'm like, where are the advocates? Where are they?
I was like, almost half of the people aren't being acknowledged, like, in their position. Like, I wonder who did we leave out?
I'm so sorry. That is all on me. That's early morning functioning for me. As you all know me, I'm not a morning person. So my apologies for that. Advocates are welcome. We're so glad you're here.
So it doesn't look like everybody's voted, but it looks like it's slowing down. So maybe, yeah. Okay. We're assuming that, like, the red line, 50%, a majority of you are advocates, but it looks like we actually have people from sort of every sector of professionals and providers who are working with survivors. So that's great. Okay, so I'll close the poll, and just really briefly about our program, the Sexual Violence Law Center. We are a nonprofit based here in Seattle, Washington, though we do provide our services statewide, and our model is to provide holistic, trauma-informed legal assistance and representation to survivors. And by holistic, we mean addressing all the legal issues that a survivor is experiencing as a result of the sexual assault. And so here we're just sort of identifying a couple of the legal areas we do end up practicing in. We serve survivors of all genders, of all ages, and just based on population, I would say about half of our clients come from the King County area. Additionally, besides representation and litigation, we also do engage in advocacy. Supporting legislation, appeals, and other reforms that will hopefully improve the systems for survivors, and then also education, workshops like this and trainings like this, hoping that those of us who are working with survivors are better informed and just engaging in better practices in our advocacy. I also wanted to, because we are also talking about technology, I also wanted to share that some of you may be familiar with the tech working group that some of our colleagues, Dana Lockhart, Natalie Dolce, folks who started looking here locally at how tech has been used to control and exert power over survivors. That was a working group that is now being housed at the Sexual Violence Law Center. The tech working group also has worked with New Beginnings in setting up Washington's first tech clinic, where survivors are able to work with tech folks in determining if their technology has been compromised. So if any of you are interested in getting involved or wanting to learn more of the tech side, the tech nature of abuse, please do reach out to us. We would love to collaborate with you. So launching into the substance of the presentation, talking about what is trauma-informed. So Natasha, do you want to talk about what is trauma-informed?
Thanks, Riddhi. So when we look at being trauma-informed, we look at considering not just the legal needs of our clients, but non-legal needs as well. Being trauma-informed is really about trying to keep the survivor from having to retell their story over and over to multiple providers. As we know, research has shown that re-victimizes a survivor and is re-traumatizing. So when we're looking at trauma-informed advocacy, we're looking at these points, but it's understanding also that there's no one size fits all when you are working with a survivor. And that's easier said than done. You know, it's once you've been doing this work for a long time, it's easy to fall into the mindset of, I've seen it all, I know it all, and I'm going to treat survivor B the same way I treat survivor M. But in reality, you can't, because each survivor comes with their own unique perspective and experiences. And so learning to adapt your advocacy to that survivor is really, really important. It's also very important, especially in today's world, understanding technology needs and barriers. You know, some survivors don't have access to internet or reliable internet. Some survivors are, you know, also working parents and they're at home now with their kids. And so understanding how to communicate with that survivor in a way that doesn't jeopardize the relationship with their kids is also very important. And really, still one of the main things that we see is a lack of awareness of systemic victimization and trauma. And you know, unfortunately with COVID, people are not able to really leave their home as much as they were for outlets. And so knowing that the system is still part of re-victimizing survivors, whether it's in their first interactions with law enforcement or coming into contact with a systems advocate or a community advocate or a judge or an attorney who is not trauma-informed, that is harmful to survivors. And so just being aware of those things and saying, okay, what has the survivor seen or been a part of already in the legal system that may be detrimental to them, and how can I help not be a part of that problem? I can think of just two quick examples recently from my cases, in understanding technology needs and barriers, and you know, had a protection order hearing where my client was petitioning for help because she's being stalked on, you know, the internet, cyber stalking, and the judge denied it, saying, you know, it's only electronic, you can block him. You know, understanding that right now, like, electronic invasions are even more interpersonal than face-to-face because of COVID. You know, and how devastating that is to survivors to hear, oh, this isn't a big problem, it's just technology. So being aware of those things and just, again, working with your survivor in a way that's not harmful to them in that instance.
So this, the beginning part is going to feel very basic for a lot of you who've been through trauma-informed training, but because we have such a large audience, it felt important to also do the 101 part of talking about trauma. So just even going through the trauma basics. So Natasha, do you want to talk about what trauma is?
Absolutely, Riddhi. So when we think of trauma, trauma is a range of things. So it can be a specific singular event, it could be a series of events, it could be a set of circumstances, but we're looking at the event, how that event then creates an experience for that survivor, whether it's harmful or threatening physically or emotionally, and then what effect that has on the survivor long term. And so, again, and when we're thinking about being trauma-informed and holistic, understanding that these things happen on a continuum, that a survivor is going to be having a barrage of trauma going on from different events for different reasons. It may not always be connected to the sexual assault, but that they're trying to process all of this at one time while also then connecting with someone in the legal system for help. And that, you know, how that affects their functioning, their mental health, their social abilities, their spiritual abilities is very, very important. Again, especially right now remotely, that a lot of conversations are happening either strictly over the phone, depending on a survivor's access, or over the phone and through online platforms, and recognizing how that impacts their story.
So thinking about trauma, many of you are familiar with trauma, like trauma with a big T and trauma with a little t. But just to go over it quickly, a lot of us recognize what sort of big T trauma is. So these are sort of like the extreme and catastrophic events that society recognizes as being impactful, like war or natural disaster or like personal injury or witnessing a death. These types of events are, everybody can agree, are traumatic, and often with these events, we know that it's going to be a life-altering experience, and not necessarily for always in the positive. The other thing is with the big T traumas, the systems individually, our communities are just much more forgiving when people need time, when people's behaviors change, and when people don't necessarily respond as they used to before the trauma. But there are also other types of insidious trauma that we don't always recognize or pay attention to. This is a video about the ACEs study, which Natasha is going to talk about. I'm actually not going to play it. I'm going to drop the link in the chat if I am able to. Okay, I am not, but I will drop the link at the end, the links at the end. But the video specifically is like an interview of Dr. Vincent Filletti, one of the original researchers around ACEs, but talking about these sort of more insidious, long-term, more private traumas. Natasha, do you want to talk about the ACEs study?
Yeah, so the ACEs study is, as I said, the adverse childhood experiences. So these are events that occur in a person's life between the ages of 0 and 17. And they can be anything from physical abuse, sexual abuse, divorce, death, homelessness, substance abuse, mental health issues. And the study looks at the lasting impact that these, each event has on a person's ability to develop social skills, mentally develop, as well as their ability to create and sustain appropriate boundaries in interpersonal relationships later down in their lives. And so the study says that the more ACEs you have, the more likely you are going to be a victim at some point, the more likely you will suffer from one of these as well as an adult, whether it's substance abuse or mental illness, the more likely you are to need assistance from the legal system. And so, you know, when we are talking to survivors, we need to take this into account. You know, what have they experienced in their developing years? What skills do they have? What resources do they have? What traumas do they have? And how can you as the advocate, whether you're the attorney, whether you're the prosecutor, whether you're law enforcement, what can you do to come alongside them in the process and help them navigate this trauma? You know, and when prosecutors hear that, sometimes when judges hear that or law enforcement hear that, they think, you know, I have to be neutral. And yes, you do have to be neutral for the, you know, the criminal process, but recognizing that you are impacting this person's life who's coming into the system, and that what you do will have an effect on how they see the system from there out. And if there's another trauma, how they'll see it if they need to report later. If you recognize ahead of time that, okay, this person has gone through some things, they've seen some things, and I need to be able to listen and hear that to help with this case, you can still remain neutral and take those things into account. And so when we talk about trauma with little t's, you start getting into the everyday nuances that happen that people chalk up as life experiences. These are things like microaggressions and transphobia, racism, historical trauma, whether, you know, this person has come from a different country and they've been, you know, part of wars or some severe traumatic experience, and then they come to this country and are experiencing other long-term trauma. Intergenerational trauma, where you may have a grandparent who was sexually abused and then sexually abuses their children, and their children then sexually abuse their children. So recognizing those things is very important, because as Riddhi said, often when we see big trauma, pandemics, wars, we have a lot more grace for each other. But the system is really hard on survivors when it comes to the little traumas, the things that you may not necessarily see happening in their individual lives that is still impacting how they appear and how they describe their story.
The other thing with the ACEs study, I mean, they said factors that seem to consistently end up public health issues and the neural development of the child. These other traumas that we're identifying on this slide, these, a lot of people may not identify these as traumas. I think there are many people who just, like Natasha said, identify these as just like life experiences and that we need to just chalk it up. But the long-term sort of insidious effect of these really end up affecting how somebody's going to navigate the systems that Natasha was talking about. The other thing is ACEs looked at the private, like in the family setting. We're talking also about these other traumas that are much more public, but they are often just so visible to us, we don't even pay attention. Like, you know, what is happening, people taking to the streets right now around criminal justice reform and race equity issues. That has been very visible for years, not necessarily acknowledged, but it has been very visible for years. And so just also recognizing that there are multiple layers around the traumas that people are coming to the court with.
Yeah, Riddhi, that's a great point. And when we look at those things, we look at them as compounding trauma. You know, what else is happening in the survivor's life that is making the trauma they're experiencing worse or more prolonged? And so we look at things like polyvictimization. So statistically, a survivor who comes to us has already been sexually or physically assaulted and abused before they come to us. So they're already living with multiple sexual or physical traumas. Also looking at no community support, especially right now in a time of COVID. As I said earlier, those who had positive outlets outside of their home have lost that in a sense. You know, as Riddhi said, we all have Zoom fatigue. And so imagine going from having a community that you can interact with, you know, as often as you need it in person. And now if you don't have internet access, not having that community, or if you do, that community is all online. And, you know, it's just not the same. I think we can all recognize it's not the same. And for survivors, losing that stability is very harmful to their overall mental health. And then also, you know, having a non-responsive legal and criminal system. You know, I think about, you know, one of my cases where my survivor had been working with law enforcement prosecutors for a very long time. And all of a sudden the case, you know, had gone through and it got, you know, reversed. And then prosecutors were like, you know, we're not going to move forward. We're just going to, you know, even if we could, we're not going to. And so thinking about how you in the system respond to survivors, and are you looking at, you know, has the survivor voiced an opinion as to what they think is best for them or what they want to happen with this case, and are you in the position to, you know, at least advocate for that to happen, even if it doesn't turn out the way they want it? Are you in the position to advocate for that? And if you are, then taking the time to do that and letting the survivor know, you know, hey, I'm gonna be honest, it may not go the way we want, but I'm gonna go to bat for you on this because you have done everything that you can do on your part. And so now we're going to respond in a way that says we're going to try to hold this person accountable. Because when you think about it, if these factors also compound trauma, you know, it's likely that if a survivor continues to experience these things on and on and on with no resolution, that person's probably not going to reach out next time a trauma happens. They're just going to say, you know, no one cares. You know, if they have linguistic barriers and they run into an advocate who is not in the mindset to say, okay, I need to get an interpreter. I need to make sure that my client understands everything. You know, you're really hindering a survivor's healing process and their ability to get justice.
So how does this play out? In our trainings, we like to present the information in 3 different ways. Usually, the way this plays out, many of you will be familiar with Maslow's hierarchy of needs, right? The idea is that we need to start at these foundational necessities, and once those are things that people have access to and are able to maintain, then you can slowly move up the pyramid towards self-actualization. I don't have the ability or I won't say ability, I don't necessarily have the energy and space to really think about morality and be creative if I'm starving, if I don't have a safe place to sleep at night. So really starting at these like kind of foundational, like basic physical safety issues and recognizing once those needs are met, then people are able to sort of move up the pyramid to becoming more fully functioning. But this is where we end up with a conflict in how what the legal system requires versus how trauma plays out. So the legal system essentially requires us to approach it and present cases in a linear fashion. It has to be chronological. It's really fact-based. You have to be emotionless. I cannot get upset. I can't have outbursts in the courtroom against my abuser despite the years of abuse and the years of like harm I've experienced at this person's hand. I'm still supposed to be very stoic and be able to get essentially the front part of my brain to like really control my behavior. But the reality is that a lot of survivors that we're working with are still often struggling at the base part of the pyramid. And this is the nature of trauma. This is the constant conflict between what the legal system requires and the reality of what trauma, how trauma manifests itself.
And so when we look at that, we look at how does the trauma play out for a survivor who's communicating about their case. And you know, as you see, there are plenty of victim barriers that are included. Fear is a very real part of our survivors' lives, especially women of color, those who identify as non-binary, people of color. Those things really do play out. You have issues of racism that, you know, right now is on a national recognized scale and being fought on many fronts. And then you also have the daily microaggressions that play into this person's fear with going to the system. It just is one of those things where a lot of attorneys, a lot of judges, a lot of law enforcement, a lot of advocates are not people of color. And so you may have this person coming to you already afraid that you're judging them or that you don't understand the things they've been through as a person of color. And so recognizing how racism and microaggressions impact your survivor and how that's going to impact how they communicate with you and not taking it personal, right? Like if, you know, this person is a 30-year-old female who identifies as non-binary, and you see them only as a female, but they're like, no, those are not my pronouns. On top of that, they're a person of color. You know, they're communicating with you in a way that's saying, I need you to recognize my story has more layers to it than what you are thinking just because of how you see me. And depending on how the system responds, that fear can either be alleviated or it can be compounded. You get into things like sleep deficit. A lot of survivors report not being able to sleep, having nightmares. And if anyone has, pulled an all-nighter in college, the less sleep you have, the less you're able to think clearly. And, for survivors who live that trauma over and over, who are afraid to sleep or who just don't get good sleep, then you're asking them to tell you a story from A to Z. And it's like, my brain is not processing those memories that way, and I can't give you those details right now. And also just a distrust of the legal system. Again, we live in 2020. We're seeing things on the news. People are inundated with the news and stories every single day. Survivors, again, have experienced trauma before. And so, again, even with your people of color, you've experienced trauma. You have a system that you know doesn't really respect you and doesn't trust your story, and now you're being asked to go to that same system and ask for help. And thinking about how those things impact your survivor, and recognizing that if your survivor is coming to you with one or more of these issues, that they're not lying. Their brain is literally trying to protect them. As Riddhi said, it's at that basic level of the pyramid. It's about survival. And just trying to be safe in their own skin again. And so helping them work through that, whether it's taking multiple breaks, whether it's saying, okay, let's talk about this part of the event and we'll talk about this another time. But recognizing those things helps. And especially right now with remote hearings, it's harder, but it's even more important that we are helping survivors understand what they need to communicate to us, and doing that in a very positive and supportive way.
So I'm seeing messages that we're breaking up and that the sound isn't coming through properly. I would love to say it's intentional to get all of you practicing around technical issues with remote hearings, but unfortunately we're trying our best. So if there is something that cuts out and you need us to repeat it, please put it in the chat or let Amy know to draw our attention to that. Just like Natasha talked about how trauma can impact the communication for a survivor, advocates can also end up creating barriers around communication related to their own responses to trauma. Natasha talked about, a client who may be identifying as gender nonconforming, and the attorney or the judge or the advocate taking offense based on the client's identity, taking it personally. Discomfort with language, even though we're professionals, especially in the field of domestic violence, especially when it comes to sexual assault cases, we often see this real discomfort around discussing terms related to sexual assault, using accurate body language, or using accurate descriptions around body, using accurate descriptions around conduct. We have a tendency to minimize. I think about working with interpreters. I always ask them before I work with the survivor, what is their term to describe genitalia, vagina, penis, penetration, rape? Because I've had interpreters, for example, who will just say when it happened, instead of saying when the sexual assault happened, or when the rape happened, or when the molestation happened. So even as providers, we need to check our own discomfort with language when working with survivors, our own personal history. Maybe we've experienced abuse, and the way we responded to it is not how we think this survivor should respond to it, and bringing our own experience into it, not to support the survivor, empathize with the survivor, but to essentially determine what the survivor is doing wrong, and what so that's also something to consider. Our own biases, our implicit biases. There's a lot of trainings around implicit bias now. Judges are going through this, law enforcement, providers like us, and advocates, but we see it constantly because it is something that you have to constantly check yourself on, something that your organization has to take on directly and have checks and balances in place to be addressing biases. Victim blaming culture. This is something we all have to always be working against. It is very, very easy to lay the blame on the victim because that is what has been happening for centuries. It is written into our literature, it's written into the media, it's written into how we are gendered and what is expected of us based on our gender identity. And so really fighting against that. The work we all do is stressful, and that also can end up having huge impacts on the types of responses that we have to survivors, and that also connects to mood, mental health, and general health. And then also if you've had a bad experience with a previous client, often bringing that history in with other future clients or future litigants that you might be working with. So these are just also things to keep in mind that can compound an already trauma saturated case or trauma saturated experience.
Yeah, and even adding to that, Riddhi, you know, research tells us that at least 1 in 4 women are victims of sexual assault, 1 in 6 or 7 men, and 1 out of every 2 non-gender conforming persons. So it is very likely that many of us sitting here on this webinar today have been sexually assaulted in some capacity. Even if it's not a full rape, it could be an unwanted touching, groping. And so there's no gender title on it. There's no age limit on it. And so also when you think about working with a survivor, you know, me as a survivor personally, I always have to remember the way I handle trauma is not the way I should expect this survivor in front of me to handle trauma. They are allowed to experience emotions that I didn't experience, or vice versa. I'm allowed to experience emotions that they didn't. And it doesn't make them less credible as a survivor. It just means that we are different human beings, which I think we all can relate, that everyone's supposed to be individual, right? So recognizing that if you have been the victim of sexual assault, or if you know someone, whether it's your child or your, you know, your spouse, your partner, your friend, you know, just because they reacted a certain way or you did with trauma, you should not then put that onto the survivor in front of you and say, I expect you to act the same way, because that's an unfair burden to put on survivors.
Thank you, Natasha. So we can't talk about trauma and trauma-informed remote hearing if we're not talking about neurobiology of trauma and how our brains respond to trauma. Just in the chat function, if you could put an X if you've seen this video.
It looks like a few have, yeah.
Okay.
This is one of my favorite videos, so I'm glad so many people have seen it.
Okay, good. I'm glad that quite a few of you have seen this. We've been having technical difficulties, so I'm not actually going to play the video. The link is in the PowerPoint, but we're also going to make sure to provide the link at the end in the chat as well. But because in anticipation of, in case we couldn't play the video, I created my own version of this video. So our brains, we do not handle only one function, right? We're not just thinking about only one thing. Or, I mean, this is my brain, but for most people, this is not true. The fact is that our brains are taking in at any given minute millions of pieces of information. We're processing it, we're observing it, we're saving it, we're recollecting it. And our brains are these like amazing, it's an amazing machine that is able to just do so much more than we can actually have our brains imagine or actually imagine. And this is because of the way our brain is laid out. There is the neocortex. Like, so when we were talking about Maslow's hierarchy, this is essentially the top of the pyramid. This is the part of the brain that lets you think about, that helps you with like reasoning and helps you develop your language and learning. This is also the part of the brain that develops later in life. These are essentially skills that children pick up as they grow, correct? No child is born able to reason with language. and with creativity. There's the limbic system. Now, this is the part of the brain, this is sort of the middle part of the Maslow pyramid. This part of the brain focuses on your emotions, memory. It controls how your body moves and functions, like what you tell your body to do, and habits, and helps you make decisions. Then there's the reptilian brain. This is the survival part of the brain. This is the oldest part of our brain. This part of our brain essentially handles our survival skills. This is the base part of the Maslow pyramid. These are the three parts of the brain that are always working in conjunction, but depending on a trauma, that your brain will start reallocating resources. Essentially, blood will flow to different parts of the brain. So if you are being assaulted, if you were experiencing trauma, a lot of times the reptilian part of the brain will kick it to higher function. And so the neocortex, I'm sorry, there's no fast way to go through this. The neocortex may not be functioning as well in the moment of a trauma. So this ends up affecting memory. This ends up affecting how somebody might reason. When working with survivors, so often you may hear like, I froze. Like, we know the story about, like, you know, say no or fight back, all those like self-preservation tactics that we've been taught as kids. But the fact is that your brain, when it's in survival mode, that may not always be how you're going to respond. So we always focus on fight, but we forget about freezing. We forget about also fawning, which is a lot of times just appeasing your abuser just to be able to survive. So kind of going back to the brain and all these like different things that you're thinking about. Now we're sitting in a hearing, in a remote hearing, where either on the phone or we're on the computer, and now we have to recollect this trauma. We're expected to testify and talk about details that necessarily our brain didn't. It's not that they don't have it, but it's hard to pull that information back out again, depending on how it's been stored, or depending on how traumas affected that memory or the response. And layered on top of that is the hearing itself, thinking about what is the judge saying, thinking about technical issues, thinking about like having to see or hear your abuser's voice like during the hearing. So this is the closest thing I could do to capture just the chaos that we are often dealing with in a remote hearing, that so many survivors are anxious about, and even during the hearing end up exacerbating their traumas because we aren't necessarily addressing a lot of these during remote proceedings. So with that, what are some trauma-informed strategies that we can be engaging in? Well, the first thing is, I mean, this was earlier in our slide, which is thinking about the intersectional identities of survivors. So intersectionality, many of you are maybe familiar with this phrase. This is something that actually 30 years ago, law professor Kimberly Crenshaw wrote about the experience of Black women. Their gender was used against them, and their race was used against them in like sexual discrimination, harassment cases, employment cases. And realizing that our survivors are coming with the multiple identities, as Natasha had identified before. So really identifying some of these individual characteristics that are going to end up being a barrier for a survivor to often access justice, just based on sort of the implicit racism, implicit misogyny that we know the the court system, the criminal system often does have. We just need to base our work around this, base our advocacy around this, and recognize that our survivors are multi-layered in their experiences and come with multiple intersecting identities.
Thank you. Those are good points, and I really enjoyed that slide a lot. And when we look at developing trauma-informed practices, it's really looking at it as how do we as advocates, whether you are a systems advocate, a community advocate, an attorney, a program manager, caseworker, judge, law enforcement, anyone who is interacting with the survivor, how do you develop these practices? I think one of the biggest things is learning from the community and not the client. You shouldn't be expecting the survivor sitting in front of you to give you a download of what it's like to be a person of color, or a woman, or a teenager, or gender nonconforming, or anything about their personal experiences. Your job is to listen, and the things you don't understand, to go and learn about them. There are an abundance of resources, and as we sit in this privileged seat of power, we have the most access to those resources, and we should be learning about these things without forcing a survivor to combat their trauma, present their case, and also educate us. Also looking at technology access, again, especially right now with COVID, it's important to understand what access do survivors have. Again, you may have a survivor who doesn't have internet access. How does that affect their ability to connect with the legal system? You may have a survivor who doesn't, who may have a phone, but that's their only phone. And so they're trying to do meetings and take care of other personal business, as well as, they may have kids, so their kids are trying to communicate with them. And so now you have to continue to put on hold. And so how does that impact them? And learning, okay, is there other way I can help the survivor with the technology? Do I just need to be more flexible and say, okay, let's set an appointment time that works best for you, not for me, what works best for you. Also looking at the appropriate language access. Riddhi mentioned earlier about, especially for using interpreters, making sure that those interpreters have the language to adequately and appropriately describe the assault on that survivor, and talking ahead of time about that. Understanding cultural beliefs is also very important. Especially in Washington State, we are a cultural hub. We are the West Coast New York, in a sense. We have cultures and people from all across the world. And so understanding how those beliefs will be impacting a survivor. But again, not going to the survivor looking for it, learning that on your own, and taking the time to do that.
And Natasha, I also related to appropriate language access. There's a second part to that. So there's the interpreter access and making sure every survivor is able to communicate clearly and has the support to do so. The second part of language access is, as providers, checking our own use of our professional language. I do not have to prove to everybody that I'm a lawyer by using big terms. I can actually, I think the sign of the smartest professional and the most able professionals are the ones who can take complicated ideas and break that information down in very simple terms. We don't have to use legalese. I always think about, I always appreciate when a judge comes in and provides some sort of introduction, maybe reads the statute or explains what they're looking for. I am ecstatic when a judge comes in and provides a simpler explanation of the statute, simpler explanation of what they're looking for the case, instead of just reading the very complicated RCW that a lot of people aren't going to understand. So I also just want to highlight that appropriate language access is also us checking sort of our professional language that we love to use to show how professional we are.
Yeah, good
Sorry,
point,
Natasha.
No, great point.
And I just want to check, is there anything else you want to say on this slide?
No, I think that's pretty good.
Okay. So one reason why Natasha and I are actually like trying to move through the slides as quickly as possible is that we wanted to actually have a little bit of space for folks to also provide impact, like feedback on what are some trauma-informed practices you utilize. We're going to be talking more about remote hearings in the next few slides, but just generally around trauma-informed practices. There are a lot of really amazing advocates. I just, based on the names I saw and professionals on this webinar. So if you can take a minute to write into the chat some trauma-informed practices that you utilize, that you think it's really important for other folks here to be aware of and to consider applying in their work. Please take a minute or two to type it in. And then Amy, if you can also be going through it, we can start reading out some of the responses people are providing.
While people are entering into, there was a question in the Q&A that I think it's a good question, in that I think a lot of folks aren't familiar with this idea of going to the community and getting information rather than the client. So if you can kind of just give an example of that and talk about alternatives instead of asking your client.
Great. So for example, let's say I'm working with an immigrant survivor from El Salvador. There's a lot of research I can do about that country and its culture instead of asking my client to provide all those details. There are resources in the community. There's NERP attorneys I could reach out to about country conditions and legal considerations and other resources that help me understand that the culture that my client is coming from and how their response to the abuse or the harm that they've experienced to help me put it in context. It doesn't mean that I can't ask the client some questions, but doing our homework takes the burden away from the client having to essentially educate us on some information that's actually readily available through other sources. Yeah, Tracy, I think that's actually really helpful. Participation in other groups. Does that answer the question? And if it doesn't, just let me know.
We've got some other suggestions here that are great. Lighting, music, breathing, smudging. Curacao mentions that she offers written materials, which I think is also really important, and letters in the first language. And if there is an interpreter used, I try to keep the same interpreter working with the client throughout the court process.
I really like Tiffany's suggestion about awareness of body language. A lot of times we're talking to clients and we're saying like, oh, do you want to take a break? And the client is saying, no, let's just keep going. But physically you're seeing them get like closer and closer, like smaller and smaller, or just like physically exhausted. Paying attention to body language is a really great way to be trauma informed. Addressing childcare. Thank you for that, Grace. I remember before law school, when I was an advocate, a lot of times the organization I used to work at, I would see the mother who we usually served going in with their children to talk to the counselor, to talk to the advocate. And I was so young, it didn't occur to me how awkward and how painful it is to be trying to talk about something that's very intimate, that's really private, that's really traumatic in front of your child, and how that affects your ability to communicate clearly. Thank you for this question about what are tips to recognize, especially in the remote setting, like how do we address, how do we kind of make up for not being in a personal space and still be able to see body language? that is a little harder, and there are going to be limitations around virtual settings, obviously. I mean, whereas for a court hearing, I would ask my client to be like further up to the camera so that it can be very clear what the record, what they're saying. Maybe when meeting with the client virtually or online, you don't necessarily, at least on the one-on-one meetings that you're having with your client, maybe not requiring that of them, because that's going to also not only give you some tells around their body language and figuring out how your client responds when they're tired or feeling uncomfortable. So kind of, I think that's where meetings before can be really helpful. Also just being much more intentional and taking breaks now, even if the client says that they don't need it, even if the survivor says that they don't need it, just like really taking those breaks, taking time, rescheduling, being willing to meet more times and over shorter periods. Those are some ways to kind of address. Okay. So any other feedback? Natasha, did you see any that stood out to you about practices?
Yeah, just running through a lot of advocates are doing things like mock interviews, mock hearings, working with a team like DD advocates and making sure that they're developing awareness, taking things slowly, reiterating to a client if they don't understand a question, it's okay to ask for clarification, transparency, lots of active listening, more
affirming what the survivor is saying,
yeah.
letting them know that they're not alone or that their responses were appropriate.
Yes.
Yeah. These are great. These are great feedback. Thank you for this. Amy, any other that stood out to you?
I think you guys hit on all of them. I will say what keeps, I don't know if you guys have read that book, the Chanel Miller book, Know My Name. And what really struck with me in that book is like, oh my God, I know I did those things when I was an advocate, where you're just like saying all the things that we say. But the way she describes an advocate is really like this really nice, smiling person, you know? And it's like, yes, it's important to have that person there, but also I think having things written down, you know, like making an extra call or an extra contact to say, I know that can be really stressful. Do you have any questions about what we talked about? So I highly recommend that book to advocates and to anyone really working with survivors of sexual assault, but particularly prosecutors, law enforcement. It's such a great description of how the system, you know, isn't working well. So anyway, that's my 2 bits. I like the idea of having things written down in a very like plain, simple language, you know, few words, a font. I think that's a helpful thing, and in their primary language for sure.
Jimmy, I think it's so the author is Chanel Miller. This is the victim of the Brock Turner case, and I think it's, what is it? Know My Name. Is that the name of the book? I always forget.
Know My Name.
Know My Name. So also with, thank you, Mary, for carefully repeating and rephrasing sentences. That's so true. A lot of times we ask people if they don't understand something and we just repeat it at this exact same shitty way we said it the first time. And that doesn't really help the situation. And so really it's like what I was saying in our PowerPoints, we try to present the information in 3 different ways. Thinking about like 3 different ways you can present that. You can present the, information to the survivor that you're working with, and not only just like phrasing it right, but also having it in other materials, like having it in a handout, also potentially as a follow-up email, and thinking about other ways that you can present that information.
I think just acknowledging too for the provider, like we know this is hard. Like I think about like how stressed we are, or, you know, maybe you're working with multiple clients at one time. So it's not like, you know, we're not sharing this information to say like, oh, this is really easy, you should do this. Like we acknowledge how difficult it is, but I think the more you practice it, the more you're able to just use it in your everyday work.
Exactly. Thank you for that, Amy. So, okay, so moving on, thank you for all this information. And like Amy said, this chat's also going to be shared so that you will have this also these additional, or we can also, what we can do is add this to the PowerPoint so that you have it all in one place. But if it's going to be available in November, we have a little bit of time to make sure you have that. So normally, as a part of this presentation, we would talk about facility information, like something really basic that we forget to do with survivors is providing them really basic information, not just about the process, but about where to go and things like that. But we are in COVID times, even though now King County, the Protection Order Office, they just moved to a virtual office. And so if a survivor doesn't have access to the technology, they are going to be expected to go to the courthouse. So making sure to provide facility information is still crucial and something to keep in mind. Parking, where to go in the courthouse, how is it laid out? I think about like with child sexual abuse cases, kids court, the idea is that you're walking the child through what court is going to look like, where the judge is going to sit, things like that. We have a tendency to forget that adults need that too. But even though we're talking about facilities, the fact is that this is supposed to focus on remote hearings. So also thinking about in a remote hearing, how would you replicate essentially the facilities information? And so thinking about the fact that, like Natasha said much earlier, survivors may not have access to appropriate devices. We're actually thinking about this in two different ways, right? One is, do they have a laptop? Do they have a phone? But then also, do they have access to the platform? Do they have access to like the system that needs to be used, like Zoom, or do they have enough data? Also thinking about like trying to be thoughtful and mindful about the kind of victimization the survivor went through. And because of that, is their technology going to be compromised? Was the phone bought by the abuser? Did they have access to the phone? Maybe there's a lot of spyware. This is where the tech working group, this is exactly what the tech working group focuses on, which is trying to figure out how technology is not only used against survivors, but how do we make it safe again? Difficulty in testifying or discussing the case depending on surroundings. Similar to, Grace identified in the chat, being able to assist with childcare when working with the survivor. That is even more crucial now than ever before, where your child, you may have to be on the record testifying about how your ex raped you while your child is maybe just on the other side of the room, attending class on Zoom. And then also court recording process. So for example, some counties are starting to live stream to YouTube and then take it down. But if I'm a victim of stalking, if there has been images, intimate images of me posted online without my permission, suddenly having my information publicly available, even if it is short term, is a whole different level of trauma. And a lot of survivors aren't aware that courts are doing this until after the fact. And it's also balancing the court's obligation to public access with concerns around public stalking and public consumption.
And in discussing this, I know me and Riddhi talked about, how remote hearings in some ways has been a godsend for some survivors, right? Like it's hard for them to go to court, to possibly run into their abuser in the hallways or trying to get to the courtroom, or have to sit next to this person or a few feet from this person and then have to face this person. Like that, for a lot of survivors, that is a very hard and traumatic part of the hearing process. And so remote hearings has removed that in some ways. So we often hear survivors are like, yes, I don't have to go to court and face this person. I feel more comfortable telling my story to the judge now. But at the same time, remote hearings, now everyone's sitting in this virtual courtroom and survivors don't have the option to leave. When you're in person, if you're an advocate or an attorney or a caseworker, you can say, hey, if you want to sit outside, I'll let the court know, I'll come get you when your case is called. But for many survivors doing remote hearings, they only have their cell phone. Most people don't have a landline. So you don't have the same ability to tell your client, hey, don't call in until I call you and tell you to chime on into this call. They have to be present for the entire duration of court. And so they're listening to other traumas. They're listening to victim blaming language, either from the attorney or a witness or the judge. You know, they're listening to condescending things that are happening in court. And so imagine you're already trying to process your own trauma and stay relatively calm before your hearing, and you're hearing all these other things happening in court, and then you're called. You know, like that impacts that survivor. So, you know, recognizing that while remote hearings are great, they also do have huge obstacles for some survivors.
And for us, one thing that we always will advocate for is that survivors have as many paths as possible to access justice. And as a part of that, with hearings, if a survivor prefers to appear in person, that being allowed. If the survivor prefers to appear by phone, if the court chooses to do Zoom, but the survivor does not feel comfortable with Zoom, the court being flexible enough to allow the hearing to be maybe telephonic. So that sort of flexibility can really, really be helpful in creating a more trauma-informed system for these remote hearings. If we're talking about litigation, if we're talking about being trauma-informed, it's really important for us to also acknowledge language. You know, we talked about language access related to interpreters and also like not using legalese, but the other thing, especially in the sexual assault context, Mary, I think I saw you on the chat. Mary does a great presentation on this, but really recognizing that we are in, as Natasha said, in positions of power and privilege as providers, and the language that we use to describe a survivor's experience has a lot of power and really can control a narrative that's created in the system. So really paying attention to how we are describing what the survivor experienced when working with the survivor, but also how we are describing what the survivor experienced when working with other providers, when writing our protection order petition, when drafting the police report after an interview, when writing an order after a hearing, that ends up essentially what's the word? I'm blanking, sorry. It can end up creating a narrative that isn't necessarily accurate of the survivor's experience if we're not using the language survivors use, if we're not paying attention to the language that we're using. So for example, on this list, the use of consensual sex terminology to describe sexual violence, saying when the respondent raped or when they sexually assaulted or molested, instead of saying when the forced sex happened. Sex itself has a connotation of there being consent, not minimizing the language. I think about like, if it reads as a romance novel, then you're probably doing it wrong, especially if survivors coming to you and telling you that they were sexually assaulted. So really paying attention to the language that we use through this process.
And Riddhi, you know, when you talk about that, I think about a law enforcement report that a couple of us in the office have read, where, you know, there was a minor child victim, there was an adult perpetrator, and the law enforcement officer wrote, you know, child had sex with the adult, there was no sign of force. And it's like, no, a child can't consent. So yes, there's force. There's some type of force for the child to have been raped by this adult. And so paying attention to that, like Riddhi said, those terminologies are very important. Prosecutors make decisions based on law enforcement reports a lot of times. So if it reads like, oh, this was just some consensual thing, there's a misunderstanding, that affects, you know, it has very, very real impacts on the criminal case.
So we have about 20 minutes left and about 10 slides. So I think we're on time, but we'll try to kind of keep moving because there's another part we do want feedback from everybody on. So what are some ongoing strategies to keep in mind around remote hearings? And so these are some best practices. A lot of these are very general practices. These are just generally good practices. But we can also put this under the umbrella of being trauma informed. And I think it kind of breaks down into 3 categories. So one is like the place. Where is the location of the hearing happening? So keeping that in mind and talking to the survivor about that if you're in a provider position. So, you know, will the survivor be able to call in a place, in a location where it's quiet, where it's well lit, where you can see them, where they're close to a power source, or that they're fully charged up? That's something that a lot of times we forget about, but it's crucial depending on hearings. Like I think about some protection order hearings where I thought it was only going to be like maybe a half an hour, and then it ended up taking the full day. If we're having a remote hearing like that, we need to be paying attention. Avoiding dead zones. I'm dealing with the dead zone right now where depending on where I'm located, my Wi-Fi cuts off. Actually having a spot to sit. A lot of us are used to like texting and walking around while talking on the phone. Even though we're using these like devices that we use in our daily lives, our conduct should not be the way we would in our daily life. So while I'm on a remote hearing, maybe that is not the best time to be like trying to like fold laundry. It's easier said than done because parents are being asked to do more than ever before and multitask, but just those are some things to kind of keep in mind. Another thing that I can't highlight enough is talking to the survivor, especially around a remote hearing, is confidentiality. If I'm dealing with a domestic violence case where I want to make sure that the respondent doesn't have access or doesn't know where I currently live, or a stalking case, or any sort of safety issue, what can be seen in the background? So for example, like just where I'm at, I'd be curious what you would notice in my background that could be potentially used against me, used to like continue to harass me or stalk me. So for example, I put up some really cute pictures of me and my siblings from when we were kids. Depending on the kind of case I'm dealing with, somebody could take a screenshot of that and then use those images. This afternoon, Shira Kaufman and I are doing a presentation on tech evidence in these types of cases and how to get it admitted. But my stalker could potentially take a picture of my background and then use those images in ways to continue to harass and stalk me. Maybe you are seeing a certain bus drive by the window, or there's landmarks that you can tell. So also thinking about safety related to what is visible in the background. What does practice mean? This is where exactly, I think somebody put it in the chat, like really practicing with the survivor and communicating with them on the platform. Maybe I normally talk to my client over the phone and that's how we communicate, but we're gonna have a Zoom hearing, so maybe I should be talking to them over Zoom to really get them prepared to use that platform. Also, how are you gonna communicate with the client, with the survivor during the hearing? As an attorney, as an advocate, when we're in court, if the survivor has a question, if the client has a question, a lot of times they can just write it down on a sheet of paper and slide it to me. We don't have that availability now. So talking to them about, are we going to maybe have a separate Google Chat screen up? Are we going to be texting each other? What are ways to keep that communication available as questions come up? If a survivor doesn't understand what's going on, I want to make sure that my client understands what's going on in the hearing. So if they're not understanding, I want them to be able to send that question to me so I can either ask the court to clarify, or maybe I can make sure to note it and tell them I'm going to clarify afterwards. We forget to mute so often. So just practicing muting and also pausing between transitions when a question is asked, and really pausing to make sure the audio is can be heard. Checking headphones and earpieces. Like obviously there were issues with sound and audio earlier today, and sometimes those little things can be faulty, and then that can really add to the complications in a remote hearing. And then even though we are talking about communicating with your attorney or advocate during the hearing, also being very clear about not texting. I'm on the phone having a hearing, and I'm also going to be getting text through that. And a lot of times I'm really bad at texting people back, but a lot of people are really good about texting people back. And just because you see a text, maybe during the hearing is not the time to respond to it. So having those conversations in preparation with the survivor you're working with. And then presenting the case, making sure you have all the login information, have it confirmed with the court. Setting your phone to make sure unknown calls are accepted. So for example, in King County, if you're on the anti-harassment docket, the court requires you to be the one that actually calls in. However, if you're on the family law calendar on the DVPO docket, the court is going to be the one that calls you. And if it's an unknown number, your phone may be set up to block it. And then the court's just going to try you a few times and then essentially say that you did not appear for the case. So thinking about those things, again, muting self. I can't be clear enough about muting yourself so that there's a clear record. We love clear records because that also helps us appeal really bad decisions. Pausing before speaking, and then also looking at like the camera and not being so distracted, and like, you know, if my kids are doing stuff, like trying as hard as possible to be mindful of like where I need to be looking and facing. So these are some best practices. Natasha, I know we talked through this list together. Are there other things that you can think of?
No, I think you did a good job. I would emphasize muting as well, but also being aware of your client's resources. So I had a client who had a cell phone, and I assumed that she was able to mute it. And the day of the hearing, I could hear noise. So I asked her, like, is that you? Are you muted? And come to find out, her phone wasn't able to mute. So she had to put something over the phone physically to block sound. You know, I wouldn't have thought about that. In 2020, I'm thinking smartphones, everyone has them, everyone knows how to mute, but her phone did not have that capability. So being aware of your client, their needs, their income, because maybe they have a flip phone, maybe they have a really old phone they were able to get, you know, at the store for $10, and does that have the ability to mute? Is important.
So with that, the next question is for folks here on this webinar, what are other remote hearing best practices that you've seen? And so if you could take a minute to put it in the chat, and so that we can share with the larger group. And just so in case you haven't seen it already, Dorothy shared a really great practice of a client used a sticky note to cover part of her phone when the opposing party was talking. So she would not have to stare at him via video, but could remain focused and composed on the hearing. One thing we really recommend to the courts is to, for judicial officers who are using Zoom for their hearings, to just have the video on them on the court itself instead of the different litigants, to avoid exactly this kind of like trauma. Have there been other tips as well?
I see make arrangements for someone to watch the children while hearing is going on, calming roads.
Yes.
Yeah, that's definitely a great option if you have it, if your client has it. Asking the client, you know, do you have someone that can watch your kids while you're doing this, even if they come to your home and have them in a different room? yeah, if that's an option for your client, check in with them and see.
I recently had a DVPO hearing where originally we had planned on calling into the court separately, me and my client, after sort of preparing for the hearing. But the client is a mother of four little ones. And in talking to her, I also realized that, you know, one of the one is going to be in class with the laptop. Another one's going to be playing on the iPad. And the youngest one really likes to take her phone from her and play with the phone. And I realized, and they live in a 1-bedroom small apartment, and I realized there was just no way that she could actually be present with the hearing, and her devices are going to be potentially in use by everybody else. And so we ended up actually meeting in person so that like she could use my phone during the hearing. So and I'm not saying that that's going to work for every survivor. I mean, we also need to consider our own health and the community that we're serving, their health as well, but being flexible where you can. Thank you, Carmen. Making sure the client has a safe space where they feel safe and there's not going to be a lot of noise around. Any other best practices folks want to share? Well, as you keep adding, hopefully, to the chat around best practices, we'll also we'll move on since we're almost near the end. Okay, Natasha.
So in preparing for difficult conversations, I think all of us in our roles have had to navigate through this at some point. The really main thing is, remember, you can only control what you can control, right? You, as the provider, as the advocate, you can control how you respond to the survivor's emotions. You can control what steps you take before and after to make sure you're doing self-care, whether that's, you know, meditating before, taking a walk after. You control, in some sense, how long the conversation will go on. And if you know you have a difficult client, or if you're going to have to have a difficult conversation, preparing your client ahead of time, like, you know, hey, you know, we need to talk about some things. It's only going to be 30 minutes. And then at that 30-minute mark, be like, okay, you know, I want to give you some time to think. So let's schedule a follow-up call. It's definitely important to have flexibility with scheduling, especially now with COVID. A lot of survivors have kids, and so they're being teacher, mom, dad, and also, you know, they may also be working from home. So allowing that flexibility with the scheduling, but really taking that time to say, okay, what can I do to make this conversation less difficult in a sense, while also needing to convey the information that's necessary. And so for you, that may also include making sure you're in a comfortable space, making sure, you know, you have the right tech access. You know, we all have Zoom fatigue, but if your client's like, hey, I need to use Zoom, being aware of what that's going to take from you, allowing your client to know ahead of time if you don't want to have your video, like, hey, I'm not going to have my video showing. You don't have to necessarily explain that. Just say, hey, I'm not going to have the video showing, but I'm here. So yeah, just, again, controlling what you can control, and also understanding that, you know, you don't have to don't take it personal. Your client, your survivor has been going through some things. They are venting at you because you are the safest person to do that with. So now allowing that to become personal and, you know, redirecting your client, you know, affirming language. I hear what you're saying. I hear you're frustrated. I hear you're angry. You have every right to be that way. I'm glad you're working with me to help me understand what you've been through so we can present this best to the court or to defense with an interview. So let's continue to work together. Maybe we need to take a 5-minute break. You know, working in those types of affirming languages and cues to help your survivor know, okay, I'm heard, I'm being listened to. Let me also try to remain calm.
Related to that, I mean, these are just some more suggestions. Also, when you're working with a client who is dealing with trauma, setting some parameters around the meeting, like what is this first meeting going to be about? I think Shelby had posted earlier and trauma-informed practices that she tries to like, strategies that she like uses, she like really tries to break the meetings down. So not everything has to be discussed in one meeting. Really paying attention and taking notes to reduce repetitive, like requiring the survivor to have to go over and over again over details, the very details that most of us would want to forget, and hopefully be able to move beyond. Continuing to think about privacy and safety concerns related to the survivor, asking, explaining why you're asking sensitive questions. So for example, in our cases, we may be asking the client how much they drank or what they were wearing that night. But if, first of all, we're asking it only if it's related to the case, to prepare for the case, and then explaining to them why we're asking so that they don't feel like they're being blamed for their conduct. And just defaulting to transparency. I mean, this is the other thing. When trauma results in conflict, a lot of times the trauma that our clients are coming with gets exacerbated by the anxiety of the unknown of the litigation process. And so our clients are relying on us to help explain and navigate the process. So defaulting to transparency, and also being okay with saying when you don't know something or when a mistake has been made. But there's obviously also a limit to that. Anger is understandable, abuse is not okay. So just also acknowledging if you are being treated disrespectfully by a survivor or a client that you're working with. And like in our office, we kind of talk about like there's no crying in advocacy, recognizing that this is about our survivors' experience. And sometimes it can be really emotional and difficult to hear the experience that our clients have been through, but being thoughtful about our emotional responses so it doesn't take the attention away from the client's experience and refocuses on us. I am here for my client. My client should not have to be trying to find tissues for me because I decided to take that moment to really talk about how their story impacted me. So something else to keep in mind. And then Natasha, do you want to take this one?
Yeah, so in being a trauma-informed advocate, and again, that applies to all of us, it means paying attention to these things. How are you communicating with the client? Are you being open and transparent? Are you using affirming language? You know, again, our survivors are coming to us in trauma, and so they may not have all of the pieces and the memories that you want. Taking the time to be very affirming, like, okay, I understand. Right now you're in trauma, your brain is trying to protect you. It's not thinking about creating memories. And so it's okay, we can work through this. Also, keeping an open door policy, allowing your survivors to know you are a safe place to come when they have questions or concerns, even if you've already talked to them about that. Also, celebrating the small victories. You know, we work in a very traumatizing field with survivors, secondary trauma, their trauma. And so, you know, if your client's like, you know, I was able to do X today that I haven't done in a long time, celebrate that with them. And again, just goal revision. If your survivor comes to you and says, I want to hold this person accountable, I want to sue them, and then later on they say, nope, I don't want to do that. Being flexible to revise those goals with them and not try to hold them to what they said originally, allowing them to lead that.
So we're at time. Just two quick slides. We're not going to show this video. The link is here, and many of you are probably very familiar with this video by that discusses empathy versus sympathy with Brene Brown. This is just research, an experiment by Jan Pansett, who has done a lot of research around neuroscience, that I will also drop the link about this research. And it really identifies how it was research related to lab rats that were exposed to a cat, and then kind of studying how that trauma affected the rats, and recognizing that once trauma is introduced into a body, once somebody experiences a trauma, their lives are never going to be the same, and recognizing that. And the last thing is being able to approach our job with humility. This is constantly something, trauma-informed practices are something that you have to constantly be attempting to achieve and rethinking and being flexible around with each client's different experience. So there are going to be times that you may make a mistake. That's okay, as long as you keep trying to apply these strategies and keep reassessing on how to best serve your client. And, you know, there was a question about, you know, we're talking about survivors. This actually also applies in the court process to respondents as well. I mean, trauma-informed practices should apply across the board to all litigants, because what it does is, first of all, it identifies their humanity, it treats them with dignity, and hopefully that means that you're going to get a better result. You're going to get clearer communication, and you're going to have people who are going to trust in your ability and the system more. We can't talk about trauma without acknowledging that there is secondary trauma. So I'm just putting it out there. That is a workshop in itself. But with that, I hope all of you found this really helpful, and will not hesitate to contact us if you have cases or if you need technical assistance in a case and it's helpful to you to talk to an attorney through your case. And with that, I'm sorry, Natasha and I had hoped we could have questions at the end, but feel free to follow up with us after this as well.
All right, thank you so much, Riddhi and Natasha. There are some great questions in the Q&A, and I haven't actually been able to figure out if there's a way for us to save those so we can come back to them. But know that that is the goal, and we are working on doing that so we can make sure to get your questions answered. Again, thank you, Riddhi and Natasha, for being here today, provided great information. Also to our attendees who also provided great information. It was great to hear from all of you. When you leave the meeting today, there should be an evaluation that pops up in your browser. Please take a moment to fill this out. Riddhi will be back at 1 p.m. this afternoon with Sheriff Kaufman, and will present Without a Trace, Gathering and Admitting Evidence of Electronic Abuse and Cyber Harassment. And then up next at 10:30, Grace Wang, Policy Director at the Asian Pacific Institute on Gender-Based Violence, will be presenting Planning for Safety for Immigrant Survivors in the Midst of Social Change. And I know that Grace was here with us this morning, so it'll be nice to have that carry over. Thank you, everyone. Grab a cup of coffee, use the restroom, no lines, right, if you're attending from home. And we will see you in a bit. Thanks, everyone. Mm-hmm.